Ms. Perkins, please place your device, place it on mute.
Okay, good morning, everyone. The 36th District Court in the state of Michigan is now in session with the Honorable Donald Comey presiding. While court is in session, there will be no talking, sleeping, chewing up gum, or reading any material. Thank you. Everyone keep your microphone on mute until the judge addresses you.
Thank you, Madam Clerk. All right, this is case number 22-181872. This is Curtis Paul Daniel versus Larry Davenport. The matter is before the court, set on for a pretrial conference on today's date. The court previously issued a scheduling order in this regard. Your appearance for plaintiff in this matter, please.
I'm Ernest Jarrett, appearing on behalf of the plaintiff. Good morning, Judge.
Thank you, Mr. Jarrett, and your P number, if you will, for the record, sir.
You just want to show that I'm older than you, huh? It's P29770.
Yeah, anybody that's not at least 3, they're back there a little bit, but that just means
Right.
started early. All right, good morning to you, sir. For defendant Larry Davenport, your appearance at this time, please. Counsel,
I didn't see Mr. Harris, Judge. If he's not connected with the court, I'm happy to say that we've resolved the matter and we just wanted to place the settlement on the record.
all right, sir. I'm glad for that update, Mr. Jarrett, and if you will, you can go ahead and make a record in that regard as an officer of this court. And,
yes.
Right ahead, sir.
We have agreed that this matter will be settled for a total sum of $4,000 paid in 10 installments beginning March of this year on the 15th, $400 per month. Those payments will be sent directly to the plaintiff, but copies of the checks will be sent to my attention. If there's a default, then the plaintiff will be entitled to a judgment of $7,500. And I believe that's it.
All right, and I know that you mentioned it already, Mr. Jarrett, but the commencement of the monthly payment amount is what date?
March 15th, Judge.
All right, I've noted the terms on the file, and I'll wait an order. Now, is that going to be an order dismissing based on the settlement, or
There'll be an order of dismissal as part of the documents. Yes, Judge.
All right. Thank you, sir. I will note these items to the file. The court will await the order. I'm going to give you the address for sending in the order if you wish to do it that way, Mr. Jarrett.
Okay.
That email address, first name is Carmen. For all the lawyers that are here that might have documents, their first name is Carmen, C-A-R-M-E-N, Banks is the last name. Carmen.
I'm sorry, what was the last name?
The last name is Banks, B-A-N-K-S.
Okay.
And that's at 36districtcourt.org. It's 36th, 30 at 36districtcourt.org.
And district court is spelled all the way out?
That's correct, sir.
Okay, thank you, Judge.
Thank you, sir. It's good to see you. All the best to you.
Good to see you. Thank you. Same to you.
All right, the court now calls case number 22-199-031. This is Portfolio Recovery Associates LLC versus Zain Al Abid. The matter is for settling for a pretrial conference. Your appearance on Portfolio at this time?
Yes, good morning, Your Honor. Michael Kirshenheiter for the plaintiff, P75722. How are you?
I'm good this morning, and thank you, sir. I'm wondering if Mr. Al Abid is here. Say something if you are. I do see that there has been submitted to the court a consent order of judgment and installment payments. And counsel that is what you would be bringing to my attention at this time. Is that correct?
That's correct, Your Honor. We have resolved the case. I have sent over the signed consent judgment to your clerk.
All right, and I have received the same. Accordingly, I'm signing that order at this time. And that would resolve this case. My clerk will get a copy of the order out. We'll populate it to the parties before the day is out. All right, thank you, counsel.
Thanks, Judge. Have a wonderful day.
The court now calls case number 22-179-759. This is TJ Medical Supplies, LLC versus City of Detroit. The matters before the court set on for a pretrial conference. Your appearance for TJ Medical Supplies, LLC. Do I have City of Detroit, Mr. Cahalan? All right, the court will recall that matter. Unless there is someone indicating. All right, the court now calls case number 22-182-136. This is Credit Acceptance Corporation versus Charday Lane and Tina Lane. The matter is before the court on the filing of a motion for installment payments. Let's see, just one other thing. All right, your appearance for credit acceptance, please.
Good morning, Your Honor. Navjot Francis on behalf of Plaintiff's Attorney of Record.
Thank you, Ms. Francis, and good morning to you. Your P number, if you will.
Sorry, P72322.
Thank you, Madam Counsel. I'm looking now. Charday Lane, if you're on the Zoom, please say something at this time, ma'am. Charday Lane, is Ms. Lane on the Zoom anywhere? All right, just one moment. Let me look at something here. And I do know that this notice was sent to the 534 number. So, but it's still, it was set for 9 o'clock, so that would give opportunity for Ms. Lane to make her way into this hearing. And she does not appear to be here at this time. The reason that the court set this for a hearing is because there is a judgment in this matter in excess of $12,000, and the defendant was asking to make payments of $50 a month. My gut reaction, my gut judicial reaction to that was that that payment was not a reasonable request. I see that the plaintiff, right, that defendant in this matter, plaintiff has objected to the garnishment, strike that to the payment plan as well. Now, tell us anything you wanted to weigh in this regard.
I would just, on the record, object to it, Your Honor. It would take over 580 months to pay it off at $50 a month. So we would ask for their motion to be denied.
Except 580 months.
580 months at $50 a month, which is unreasonable.
Who calculates how many years is that? The bottom line is this, it does appear to be unreasonably low. I set the hearing to see if the defendant was in maybe a better position than $50 offer amount. Maybe it could be resolved, but she has not appeared. I'll deny the motion at this time under these circumstances. And I'm signing an order consistent therewith. Thank you, counsel.
Thank you, Your Honor. I do have 2 more cases, Judge.
All right, we'll get right to you. Madam Counsel, are your cases styled under, well, who's the plaintiff in your matters?
Citibank, Your Honor.
I'm sorry?
Citibank.
This is case number 22-198-513. This is Citibank versus Karen Hope. The matter is before the court set on for a hearing. Looks like this hearing addresses the defendant's motion indicated that she's in the process of obtaining a lawyer and she just returned to work. Your appearance regarding this matter, counsel.
Najat Francis, P72322 on behalf of plaintiff's attorney of record.
All right, thank you, counsel. Do I have Karen Hopes on this Zoom? Ms. Hopes? Karen Hopes? Let's see. It looks like, Madam Counsel, that the correct notice was sent out. It has the correct Zoom number on that notice. And that notice was sent out on the 13th of January. Again, I'm looking for Ms. Karen Hopes. If you're on the Zoom anywhere, please say something at this time. If you're on a device where you're muted, just press *6 and you'll be able to speak with me. It does not appear that the defendant has appeared regarding this matter. I set it up for a status and scheduling conference, although the document that is not a formal answer. It appears to be an attempt to provide an answer. Let me ask once again, is there a Karen Hopes on this Zoom? Karen Hopes. All right, Counsel, your pleasure at this time, Madam Counsel.
Your Honor, we would request a default judgment to enter at this time.
All right, inasmuch as defendant has failed to appear for the duly scheduled hearing, the court will at this time find that defendant is in will enter a default judgment upon presentment regarding this matter. So forth.
Thank you, Your Honor.
Thank you, Miss Perkins. You have to, unless you are disabled, you do have to sit up and be in the courtroom. You could elect at this time to turn your camera off until your case is called. But man, you can't be sleeping in the bed while you're in the courtroom. So you have to sit up and be engaged, ma'am. Thank you. And Ms. Francis, you said you had another one.
I do for Citibank.
All right, that would be case number 22-199-287. That's Citibank versus Jimmy C. Davis. Now, the matter is before the court on the setting of a status and scheduling conference. It appears that the court received something. The court did receive an answer that was presented to the court. Your appearance for the plaintiff in this matter, please.
Najat Francis, P72322 on behalf of plaintiff's attorney of record. Your Honor, defendant has filed bankruptcy in this matter.
Right. Do I have plaintiffs strike? Do I have counsel for defendant in this matter? Yeah, I noted that that there is an attorney that has filed an appearance for defendant Davis, and just checking to see if that attorney is here. Thank you, counsel, for that update regarding the notice of a bankruptcy. The court will anticipate an order for stay with regard to this matter. With the notification, I will indicate that the file is stayed in anticipation of the order. Thank you, Madam Counsel.
Thank you, Your Honor. I believe we did email over a dismissal for this one based on the bankruptcy filing.
All right, Ms. Francis, where did you send it? Because I don't have it yet. Which email address?
I am not sure, Judge. I just show the notes that it was emailed to the court, but I can have them send it to your clerk's email, Your Honor.
Carmen.banks. You have that one already? All right.
Yes.
Yeah, make sure.
Thank you.
All right. Thank you, Madam Counsel.
Thank you, Judge.
Ms. Baker, which matter are you on, ma'am?
Pasadena Investments versus Winnie Banksy, Your Honor.
That is case number 22-198745. This is Pasadena Investments LLC versus Winnie Banksy. The matter is before the court on the court setting in a status and scheduling conference regarding this matter. Your appearance at this time, counsel.
Good morning, Your Honor. Denise Baker, P53670, appearing on behalf of plaintiff Pasadena Investments.
All right, thank you, counsel, and good morning to you. I'm looking now for Wendy Banksy. I have received the answer in this matter. Ms. Banksy, if you're there, please say something at this time.
Good morning, Your Honor.
All right, good morning to you, ma'am. This, of course, is a case involving a claim for $3,710. And looking at the answer that you filed, it indicates, well, most of what I see is that you agree with the allegations that were made. So what's your issue here?
No, I don't have an issue. I was waiting for the payment plan to be sent to me, and by the time that it got to me, I also got the order for the court. So I didn't know if I was supposed to come to court, then send the payment plan agreement. I never done this before, so that's really why I'm here. But yeah.
That makes sense. What happens is that when the matter is proceeding in court, I don't know what's going on when there may be discussions going on. So the court process goes on while that other process is going on. Have you spoken with Ms. Baker regarding a resolution of this matter at all, Ms. Banks?
No, Your Honor, I did not speak with Ms. Baker. I called the plaintiff's attorney. I think it says it's Scott Renner. I called that office number, and that was how I obtained the payment plan details. But I didn't speak with Ms. Baker. No.
Your Honor, I'm sorry, Your Honor. We did send her a consent judgment back in December, and we would just need her to sign and return that to file it with the court, and that would resolve the matter, and she can make the payments to our office.
So did you receive the consent, the proposed consent judgment, ma'am?
No, I did not, Your Honor. The only thing that I received was the motions to pretty much file what I filed when how do you call them? Somebody came to serve me. That's what is that it? Because I'm not sure that's it.
No, and we can resend that to you, ma'am. Is the Roxbury Street address correct?
Yes, it is.
Okay, we can send that out to you again, ma'am.
Okay, thank you.
Ms. Banksy, you're in agreement with the consent that you discussed over the phone to get this resolved. Is that correct?
I didn't really discuss any consent over the phone. I only asked for a payment plan. So I'm not sure that's the same thing. Yeah,
that would be a consent judgment that has a payment plan to it.
Okay, understood.
All right, so what's gonna happen here then is that what I'm going to do is I'm going to adjourn this for about 3 weeks, just to give the parties an opportunity to exchange the information. They're going to be sending out to you a consent document based upon the agreement that you have already discussed. And so you are to sign that and send it back to that office, and then they'll send it to the court. I'll sign it. You'll get a copy, and the other side will get a copy. And you can go ahead and commence making payments to that office. And as long as things proceed in that matter, then that would constitute the end of this case. I'm going to set a control date so the parties can come back if there are any problems. And that control date in this matter is going to be this. I'm going to set it for March the 2nd. March 2nd at 9:30. 3-9:30.
Okay.
The case has been resolved, but this is a control date that if anything goes wrong, then you would make sure that you're here on 3/2/23 at 9:30 a.m. Same Zoom number.
Okay.
Ms. Banksy, are you able to receive that document via email, or do you need it mailed to you?
I can do it via email.
What is the email address?
So my first and last name, WINNIEBANGSI, and then 91@gmail.com.
I really don't want you to do it that way on the Zoom because we're on, we're.
Oh yeah, shoot, other people.
So you can chat it to her if you know how to do that, or I can put the two of you in a breakout room and you can exchange it that way. That's why I threw interference there. I hope that you wouldn't put your information out there because, you know this type of society we live in nowadays, okay? So do you know how to chat it to Miss Baker, Miss Banks?
No, I do not, sir.
Okay. All right. So
I can do that. I believe I received it, Your Honor, so I'll chat it to her for her to confirm.
Okay, all right, let's do it. Okay, so you should be all set then, and I'll await the order by way of email to the court. You have the court's email address. You can send it
I do,
directly
Your
to me.
Honor. Yes, thank you.
Let's get this done. Once that's signed, then this case will be closed, based upon the judgment that is in. All right, I wish you well, both sides.
Thank you, Your Honor.
Thank you, Your Honor.
I previously called TJ Medical Supplies versus City of Detroit. Anyone present on that matter? This is the suffix 9759. I have TJ Medical Supplies. I have the City of Detroit regarding this matter.
Your Honor, I can cover on behalf of the city.
Your appearance at this time, Council.
Oh, I'm sorry, hold on. Good morning, Your Honor. Alfred Ashew, PA 2536 on behalf of defendant City of Detroit.
All right, thank you, Council, and good morning to you, sir. This is a case where Mr. Bazzi's office is involved in this, and I've not gotten a response from plaintiff's counsel regarding this matter. And it looks like from your office, Mr. Cahalan was or is the attorney assigned on this. You can bring to this at all, Council?
I'm sorry, Your Honor, your volume is just a little bit low.
Okay, sorry about that, Council. I was asking if there's any information you could bring to this matter at this time.
No, Your Honor.
All right, so it's kind of uncommon for that office, Mr. Bazzi's office, to not appear. So my inclination regarding this, I do have the city having filed its response, or I should say its answer. My inclination is to reset it and make sure that everybody has notice in this regard.
I have no objection to that, Your Honor.
All right, Council. So that's what I'm going to do. I'm looking at the notice, in fact, and have the Zoom in. So yeah, I'm gonna renotice it. So I'm gonna set it over for the I'm gonna set it over for the 6th of March, 3/6 at 9:30.
Thank you, Your Honor.
All right, thank you, Council. This is case number 22198272. This is ASP Care Plus Pharmacy versus Titan Insurance and Nationwide Insurance. Today is the date and time the court has set for a
Judge, there's a lot of interference I can hear from the phone on at the bottom of the screen.
got a person on the phone number beginning in 608. You must stay on mute. You're interrupting the entire hearing. All right. Your appearance for plaintiff ASP at this time.
Good morning, Your Honor. Sandra Kazmika appearing on behalf of plaintiff ASP Cares, P number 84575.
All right. Thank you, Councilman. Good morning to you. Let me have other counsel regarding this matter, Titan Insurance Company.
Good morning, Your Honor. Katrina Hutari appearing on behalf of defendant Nationwide, P number 86225.
All right, thank you, counsel, and good morning to you. Are there other, is there any other counsel regarding this matter? Because I see Titan and Nationwide, looks like, all right, very well. Anybody else appearing in this matter? All right, so I set this up for a status and scheduling conference on today's date. I see that there have been initial disclosures, et cetera. Update me and tell me what you need from the court at this time.
Your Honor, per the Register of Actions, we just wanted to clear it up between defense and I. It seems that the whole claim was, I mean, the whole case has been dismissed with prejudice, and I don't know if that's a clerical error, but the ROA shows that. So we're just trying, I mean, we would like discovery to open, but we just want to make sure the case is still in good standing with the court.
Yeah. I'm seeing that, and it has as to defendant number one. Well, it also has as to plaintiff number one. I will indicate that that the matter should not be dismissed, and I will place in any scheduling order that any dismissal is set aside with regard to the plaintiff in this matter and with regard to Nationwide. Looks like, so are those the only two parties or the only two parties that are involved in this matter at this time?
That's correct, Your Honor.
Ms. Hatari, you were saying that that's correct to your knowledge?
Yes.
Okay. All right. So I'll set up a scheduling order, and part of that order will be an order reinstating the case, just so that we make clear that there is no dismissal as to those parties at this time. All right. So I'm thinking 60 days discovery and setting a hearing for pretrial in this matter, and we'll address any other issues that may arise. So the court will be setting this matter on date for your return date. Well, that's going to be April the 11th. April 11th, and that's going to be at 9:30 a.m. 4/11, 9:30 a.m. You'll receive a scheduling order from me that allows for discovery through that date, and it will set that date as the next hearing date, and discovery is open through that date. Moreover, you will note on the paragraph number 6 of the order that you'll receive from me that you have the right to file motions dispositive or otherwise, and actually set them for hearing on that date. Should there be opportunity to raise some issue or there's some issue that comes up. All you need to do, the only requirement is that you notify the opposing party at least 10 days before the hearing. So give the other side at least 10 days to respond, and I will hear the motion on that date. I realize that this changes rules regarding the filing of dispositive motions and otherwise. But under my order, you could file a motion, and as long as the other side is given at least 10 days notice before the hearing, I will hear the motion on the next action date, which is 4/11/23. That does not preclude you from filing motions in the future. But again, this is to expedite things if the issues are narrow and there's something you'd like to be heard on as soon as possible. So you have a motion hearing date. If there are discovery issues that arise, you can set the motion to compel those kind of issues for the 11th. So that date is a pretrial date, but it can turn into a motion hearing date or a date to address issues that you might want to bring before the court. Only thing that's required is a 10-day notice to the other side. All right, so you'll receive that in writing, that order from me in the next few days. I wish you well. Unless there's something else you need to bring to the court's attention.
No, that's all, Your Honor. Thank you.
All right,
That's all, Your Honor. Thank you.
It's been a good day, both of you.
You too. Thanks.
All right, this is case number 22192239. This is Dearborn Total Automotive versus Bernetta Perkins. The matter is before the court, set on for a status and scheduling conference. The court is in receipt of the answer to the complaint. And a critical part of that seems to be that there was some effort to compare your appearance for Dearborn Total Automotive, please.
Yes, good morning, Your Honor. Trevor Stratton, P65124, on behalf of the plaintiff.
Counsel, morning to you. Do I have Bernetta Perkins on this Zoom?
Yes.
All right, good morning to you, Ms. Perkins.
Good morning, Your Honor.
All right, ma'am, are you ill? What's going on with you, ma'am?
I paid this car note. I was in another state in Texas. So when they came and towed it, and I don't understand why they took it away from me, because I was actually going to school for ministry with TD Jakes ministry services in Texas. And I was thinking about moving down there because I was going to school, and I called the people. I called Dearborn Auto. I just made a payment and I paid it in full for the whole month, I believe. And the next day they came and towed my vehicle, and I was in a shelter because I didn't have nowhere to stay. I just got down there for school, so I was just trying to get settled in. And I was letting them know that I'm thinking about moving down here. What would be the procedures to get things transferred over to Texas? Well, when I woke up the next morning, the shelter people came to me and said, they torn your truck off the lot. I said, oh, no, that's not my truck. I just paid my car note yesterday in full for the whole month. So I don't understand why they took it. And then when I reached out to them, they was just so rude and disrespectful. It's like, is your business. But you guys just took my money. Are you serious? Like, y'all just took my money. I made a car note in full. I don't recall being late. And if I was, I always pay like a whole month. They didn't mention to me that I was late over the phone, nothing. They were so happy to take my money. It was regular business day. And next day they just came and towed my truck away. And they never gave me a reason why. They left me stranded in Texas because at the time I still haven't made a choice if I was going to move there or not. I just got down there and I was just trying to see would it be.
Let me stop you. Let me stop you because you're repeating the same thing about 3 or 4 times. Obviously, the vehicle was repossessed, and the vehicle, the charges associated with that have inerred to this becoming a suit against you for damages owed under the contract that you signed. Let me ask you, Counsel, because I'm seeing $13,000 here as the claim in this matter. Was the vehicle, when it was repossessed, was the vehicle sold? Is this a deficiency balance?
No.
No, Judge, this was,
I'm not talking to you, ma'am. I'm talking to the attorney now.
Oh, okay. I'm sorry.
Go ahead, Counsel.
no, Judge, this was a lease vehicle, so the balance would be made up of remaining lease payments, any repairs that were done to the vehicle. There's a few other repossession fee.
Counsel, sorry, sir. My question is kind of narrowly drawn here. Was the vehicle, she says it was repossessed. Was it sold? Was there a deficiency balance? So what happened with regard to this vehicle?
I'm sorry, Judge, yes, I was trying to explain that. No, it's a lease vehicle, so the remaining charges are from remaining lease payments, any damages that needed to be repaired on the vehicle when it was repossessed, repossession fee. There is a breakdown of the balance on the second exhibit, if Your Honor has access to the complaint. But no, it's not a deficiency, it's a lease.
Got it. Thank you, Counsel. Hold on 1 second. All right, very well. So it sounds like to me that the defendant in this matter is alleging that that the vehicle was not properly taken, and that that there are certain rights that she wishes to assert in that regard. So what I'm going to do is I'm going to set up a period of this discovery in this matter and an opportunity to file motions to resolve this case one way or the other. Because it seems to me that Ms. Perkins is saying that she does not owe anything in regard to this vehicle. So you'll likely need to file a motion to narrow the issue in this particular matter. I'm going to set it up on a pretrial scheduling order that I'm going to send out. That order is going to set this matter with the next hearing date, which is going to be about 60 days, since that's going to be on the, that's going to be on the 10th of April, 4/10/23. You'll get a scheduling order in the mail from me with 9:45 is the time on that date. You'll get a scheduling order that allows for discovery. It also allows for filing of motions. So I'll see you on the next action date. And if there's any motion, we'll deal with the motion at that time.
Your Honor,
Yes, ma'am. Go ahead. Quickly.
is this some kind of way I could get my money back or some money back off this? Because this was wrong. I didn't do nothing wrong.
Let me stop you before you start talking on and on. If what you need to do is you need to talk to a lawyer if you believe that there are some rights that were violated, ma'am. You need to talk to a lawyer to see if there is anything that you can do in that regard. It looks like to me that you signed a lease agreement and that when you fell behind in one or more payment on that lease agreement, that the vehicle was recovered and that therefore they are enforcing the rights that would be due under the balance of the lease. But I don't know all the facts there. I'll have a trial on this if it gets to that point, but that's what it sounds like this case is about. And the laws regarding paper, that is when you sign a paper agreement, that you still owe money on the paper, even if you don't have the car anymore. So a lot of times people don't understand that part of it is that, yeah, the paper gives you the right to have the car under certain circumstances, but it is the paper, the contract that obligates you to make the payments. And if you don't keep up with the payments, then the car can be taken from you and the payments can still be required. That sounds like what's going on here, although I'm not 100% sure that that's the case. You might want to talk with a lawyer to see if there is something that you can do about those set of circumstances. And I'm giving you until the 10th of April. You can ask the other side, you can put in writing to Mr. Strand's office, any documents that they have. If you need any documents related to this case, any claims that they have against you, an accounting of how they came up with the amount that is owed, any of those items, if you request them in writing, send a letter to Mr. Strand's office. Over the next 60 days, they're required to supply that information to you. They may send requests to you as well. They may send questions to you, interrogatories. They may send requests to admit. They may ask you for documents as well. And over the next 60-day period, you are required to respond to any documents that might be sent to you. And then again, the next action date is 4/10/23 at 9:45 a.m. You'll get a document in the mail from me, right? Good luck to both sides. I'll see you in the next action date.
Thank you, Judge.
Thank you. Good day.
You too.
Thank you.
Thank you, ma'am. All right, this is case number 22192504. This is Garner Properties and Management LLC versus Maria Burnell. The matter is before the court, set on for the status conference. At a previous occasion, there was a need for a Spanish interpreter, and the court set the matter over in that regard. All right, your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Hamzi Sob on behalf of plaintiff P2080.
All right, thank you, counsel, and good morning to you. Do I have an interpreter, a Spanish interpreter present at this time, certified? I have a certified Spanish interpreter. Well, it doesn't look like I do, although I have the request form contained in the court's file. Do I have Maria Burnell on the Zoom?
Sí. Sí.
I don't know what happened, but I don't have an interpreter here. Just
What's
one
the
moment.
case?
Yeah, it's 2219254. Yeah, I see the order for an interpreter, but I don't see that no interpreter is here. So is there a way that we can correct that today, or we gotta reset it?
I have to call the person that ordered the interpreter.
That's not likely. So it's not likely to get someone today.
Just get past it, because she's probably in more than one courtroom.
All right, thank you. Council, I'm gonna pass on this for just a moment. We're gonna see if.
Your Honor, I don't mind if you want to reset it.
Yeah, give me a few minutes. She's making a call, and in the next few minutes, I'll know whether we need to reset it. So I'm gonna keep you in front of me and get right back to you on this.
Sounds good. Thank you, Your Honor.
All right, thank you. All right, this is case number 22-195165. This is Midland Credit Management Incorporated versus Rufus Beal. Matter is before the court, set on for a scheduling conference. Your appearance this time for Midland.
J. Baig, B-A-I-G, P36820, appearing on behalf of plaintiff and the attorney of record.
Thank you, Mr. Baig. Thank you for your patience this morning as well, sir. Do I have Rufus Beal on this Zoom? Rufus Beal, if you're on the Zoom, please say something at this time. If you are muted, you can hit *6 and that should get you off of mute. Rufus Beal. The court has received an answer filed by Mr. Beal, and thereupon the court set up a status and scheduling conference on today's date. The court also sent out a notice of the same, and in that notice, it provided this particular Zoom number for a defendant to appear. All right, that hearing was set for 9:45. It's 10:30 at this time. Counsel, your pleasure at this time, sir.
Your Honor, I'm requesting a default judgment. The damages, $769.50, cost of $144 for a total of $913.50. How would you like me to submit that? 7-day rule?
No, the court will determine that the defendant is in default by its failure to appear upon notification, and the court will enter judgment upon presentment. You can submit that. You can submit that by way of email. You can do it under 7-day rule.
Very good, Your Honor. I'll do it either by email or I think I do have your clerk's email address somewhere.
Yes, sir. And
thank you.
I marked the file awaiting order.
Thank you.
Thank you, sir. Good day to you.
You too.
Yes, she's in multiple courtrooms. She's about to call her. She should be zooming on short.
All right. I'm getting some indication on the Garner property matter, Mr. Shaw, that the interpreter is in multiple courtrooms. This case is already almost an hour behind. So, I mean, if you wish, I will go ahead and adjourn it. We'll try and get her here on more specifically on this file on the next page.
Your Honor, I don't object to an adjournment. I don't mind. I mean, if Ms. Bernal wants to go through it today, I'll be more than happy to wait. If not, then I don't mind an adjournment, Your Honor.
All right, so let me do this. So by 10:45, it would be an hour that this case has been pending. So I'll give it another 5 or 10 minutes, and if we got an interpreter at that time, we'll move forward. If not, I'll adjourn. So I'll get right back to your file is right in front.
Sounds good. Thank you, Your Honor.
Thank you, Counsel. And Mr. Jurek, I'm coming to you right after I deal with a couple of city matters. I'm calling now 22-199-785. This is Tox Testing Incorporated versus City of Detroit. The matter is before the court on the setting of a status and scheduling conference secondary to the court having received answer in this matter. Your appearance at this time for tox testing.
Good morning, Honor. Michelle Khan appearing on behalf of the plaintiffs, P75585.
All right, thank you, Ms. Khan, and good morning to you, ma'am. For City of Detroit, your appearance, please.
And good morning, Your Honor. Mary Beth Cobbs, P40080, appearing on behalf of the City of Detroit.
Thank you, and good morning to you as well, Ms. Cobbs. I do see where the appropriate answers and affirmative defenses have been submitted herein. I don't know if there have been any discussions or how far the case have advanced. Your thoughts, Ms. Khan? Are you just looking for a scheduling order?
Yes, Your Honor. That's essentially, I believe, what defense and I need.
That's correct, Your Honor.
All right, very well. I will issue then my typical 60-day order, basically 60 days, but that will take you out to April 10, and that's going to be set for 10 o'clock a.m. That order will allow discovery to be open through that period. It also allows for other things like filing of motions, and I'll review the matter. I'll review the matter on that date at a pretrial conference. It's 4/10/23 at 10 o'clock a.m. Any other issues at this time that you need the court to address?
No, Your Honor.
None from the defense, Your Honor. Thank you.
Thank you, and good day to the two of you. Thank you for your patience.
Thank you, Your Honor.
Thank you.
The court now calls 22-196-447. This is Narvina LLC versus City of Detroit. The matters before the court set on for a status and scheduling conference. The court is in receipt of the answer and various affirmative defenses in regard to this matter. Your appearance for Narvina, please. Any appearance for Narvina? Looks like Attorney Mackey, Farad Hassan Mackey. I don't see anybody present on that matter. All right, your appearance for the City of Detroit, please.
Yes, good morning again, Your Honor. Alfred Ashew, PA 2536, on behalf of defendant City of Detroit.
All right, thank you, Counselor. Good morning to you. All right, so I know that you've done the city's part on this and filing an answer. You have any contact with the plaintiff counsel on the other side? Any idea?
No, we haven't had any contact yet. And I found out about this hearing by monitoring the docket online. The Register of Actions says that the scheduling order was sent out, but we did not receive it. And I noticed on the Register of Actions, it shows that the appearance for defendant was entered after that order. So I'm not sure if that has something to do with it, but I just requested we have some time to conduct discovery.
All right. Yeah, there's a bit going on here. I don't see any of that. All right, Council. So what I'm going to do, I will set this up on a scheduling order. I see some the Register of Action looks like it has some confusing stuff on it, whatever it is. I have not previously issued a scheduling order. There's not one contained in the file, so I will issue one today, and I'll get it in the mail. That'll bring you back on the 10th at 10 o'clock a.m. 4/10/23 at 10 o'clock a.m. I'll get an order out of the mail today. That allows for discovery, of course. All right, thank you, Counsel.
Thank you, Your Honor.
All right, this is case number 22-199-238. This is Mount Calvary Evangelical Lutheran versus His Management LLC. The matter is before the court, set on for a scheduling and status conference. Counsel, your appearance.
William Jerzak, P73185 on behalf of the plaintiff.
All right, thank you, Counsel, and good morning to you, sir. Do I have anyone present for a defendant in this matter? His Management LLC. Anyone present on this Zoom? So I did receive an answer from someone, looks like the last name is Rosier, Mark Rosier. All right, counsel, what's going on here to the best of your knowledge, sir?
I did receive the answer, and the answer I received basically agreed with all the allegations in the complaint. So I would just have been moving forward with a motion for summary disposition based upon that, but given the non-appearance, I'd ask for a default judgment.
All right, one more time, any person for His Management LLC, someone by the name of Mark Rosier, and any other person in regard to this matter. The court in review of the file, a notice was sent out in this matter on January the 17th, providing the correct Zoom address and the time at 10 o'clock. Inasmuch as the defendant has not appeared in this matter, the court will find the defendant is in default and accordingly will allow for entry of judgment upon that default. And you may present your judgment, counsel.
Thank you.
She had to dial Zoom number 360336. She probably dialed 534. Yeah. It's 360-336.
All right, and you didn't hear anything.
That's the interpreter. She was dialing 534. I told her she had to dial the other things. Yeah, they told her to dial 534. She had to dial.
Oh, I'm sorry. Excuse me. I'm sorry. Did they call His Management?
Yeah, I already, in that case, I just entered a default because I got no response.
Oh, I'm sorry. You know what? I ran to the bathroom right quick. I'm sorry. I ain't want to go to.
Looks like you're probably gonna have to file a motion.
Yeah, I just ran to the bathroom. Come right back.
Yeah, well, that's, let me see if the attorney on the other side is still here.
Yeah, I've been right here. I'm sorry.
Yeah, but when I called the case, you had to be here when I called the case, sir.
No, I'm sorry. I ran right to the restroom. I'm sorry.
Yeah, you're gonna file a motion, contact the other side of this matter. It sounds like what was said upon me looking at that matter, sir. It sounds like you did not disagree with the case.
No, I didn't disagree. You know, it was just, I just went to a hardship, you know, just like this was winter. Ain't no snow, you know.
All right. So what you have the right to do, you're gonna get a judgment. When you receive that judgment, you can file something with the court and ask that it be set aside and that you be given another hearing. The other thing that you can do is to petition the court and or reach out to the other side to set up some type of payment arrangement. Because it sounds like that's what you're going to be trying to do with this, right?
Yeah, that's all. That's all. Just payment arrangement. It was just, I had agreement already. I just couldn't fulfill it because, you know, times got kind of hard for a minute.
Got it. Yeah, and I see that it is a case that where they're looking for more than $10,000. So what happens is that if the judgment is entered against you for that amount or whatever, when you receive that, all you need to do is file a document for partial payments, and I will look at your request for partial payments and then make a decision about how much you pay on a monthly basis.
Okay.
And again, the judgment is going to be entered by default, meaning that because you were not here at that moment. If you want the that judgment set aside, then raise that issue. When you get the judgment, file paperwork on the second floor, and just point out that you were in the hearing, but you stepped away, and that's when the judgment was entered, and that you'd like to have another hearing. So you could go that route, but it sounds like the route that you wanted.
Yeah. Mhm.
Okay.
Oh, I can't hear. I'm sorry, I didn't hear you on that one last part.
Yeah, I was just saying that it sounds like you simply want to file a motion for partial payments and figure out a way to start paying on this.
Yes, that's all. I'll pay it.
Yeah, once you get the judgment, and once you get the paperwork in the mail that tells you how much is owed, then what you do is file a motion with the court, a motion for installment payments, and I will get that and make a decision about your payments.
Okay. Okay, I'll do that first thing.
I wish you well, sir. Good day to you.
Okay, thank you so much. You have a good day.
Spanish interpreter speaking.
Yeah, I know. Just one moment. I'm looking for the file now.
What was the last location?
Yeah, I got it. All right. And Madam Interpreter, just stand down for a moment. I got two things I need to call. I'm coming back to
Your Honor, as I'm speaking to you, I'm being told by my agency to go to juvenile Lincoln Hall because my 10:30 was started already, and I don't know what to do.
No, you gotta stay here. You gotta stay here for right now. That's what you have to do. All right. So you tell me to stay right where you are. All right. Well, let's do
Dina?
this. We're back on the record in 2504. That's Garner Properties versus Maria Barnell. And Counsel, you previously ended your appearance, sir, regarding this matter. There is an interpreter present. Your name for the record, ma'am.
She's on the phone.
Madam Interpreter, you got to get off the phone, ma'am. The case is up now. Your name for the record, ma'am.
You're on mute.
Unmute
Sarah
yourself.
Palero, Spanish interpreter.
Thank you, Ms. Valero, and good morning to you. Raise your right hand to be sworn at this time, ma'am. You do solemnly swear or affirm that you will interpret the truth from English to Spanish and Spanish to English to the best of your ability. So help you God.
I do, Your Honor.
All right, thank you, Ms. Valero. And I know that you've been running around this morning and that you have something else scheduled. We had an order for you to be here regarding this case at 9:45. I know that you have somewhere else to be. The attorney is present, and looks like Miss Maria Barnell is present. Is that correct, Miss Barnell?
Señora Barnell, ¿está presente?
You can unmute yourself.
Yeah. Sí, sí estoy aquí.
Yes, I'm here.
All right. And this case is about a claimed debt of $3,658.51. Do you understand that, Ms. Barnell?
Señora Darnell, esta es una demanda por la cantidad de 3,658. ¿Entiende usted eso?
Yo lo entiendo,
I
pero
understand.
¿puedo decir algo?
I understand it.
All right. And what would you like to do to resolve that, or what do you think should happen here, ma'am?
¿Qué quiere hacer para poder resolverlo?
Mire, lo que pasa es que como con las evidencias que fuimos anexando al folder, ellos, si toman en cuenta, mi hija pagó esa cantidad porque a ella le estuvieron quitando el dinero. Lo demandaron por la Corte 24 para que pagara 2,591. Ella terminó de pagar ese dinero el 31 de diciembre del 2020. Pero
Señora, tiene intérprete, no soy máquina. Momento.
Oh, disculpe.
Your Honor, I have an evidence folder here. My daughter had paid the amount of $2,591. She paid it in December 31st.
Pero adicionalmente le quitaron 1,102 más 254 el abril 21 del 2021, que hacen un total de 3,958. Ella ya pagó ese dinero.
They also additionally took 1,002.50 on April 21st, totaling an amount of 3,958.
Stop you for a moment. And Mr. Shaw, you heard that elocution, if you will. There's an indication that a payment was made as late as December of 2022 regarding this case. Counsel?
Your Honor, I'm sorry. I think you have another interpreter that logged into this account.
Yeah, well, you're here on this one. So
Gracias.
you got to stay here for just a moment. All right, Mr. Shaw, you've heard the statements made. Any response, sir?
Yes, Your Honor. The payment was made, and we're not disputing that payment wasn't made. We're stating simply that there still remains a balance.
Sí, su señoría. Usted tiene una respuesta. Sí, su señoría, la tengo. Lo que pasa es que no estamos diciendo de que no han habido pagos. Simplemente estamos diciendo de que hay pagos que todavía faltan.
And Your Honor, if the court would open discovery, I'd be happy to substantiate all the claims to the defendant. I send her a ledger and proof of the payment that she made, which is reflected on the ledger. That way, it helped clear any confusion regarding.
Su señoría, si la corte me permite, yo le puedo enviar a la señora descubrimiento y toda la documentación, y así no tiene ninguna confusión.
I believe you're muted, Honor.
¿Puedo hablar?
Can I speak?
No. Are you able to hear me, Mr. Shaw?
Yeah, I can hear you, Your Honor.
So my question to you is this an ongoing relationship, or is this some type of rental relationship that no longer is existing?
It was a relationship.
Interpreter needs to translate, Your Honor. I'm sorry.
Yep. She has to translate, then you can answer, counsel.
But interpreter did not hear over my own voice, Your Honor. I apologize. Can we start again with his last sentence?
Yes, ma'am. I'm asking of the attorney whether or not the relationship with Garner Properties is over with, or if this is an ongoing relationship.
Si le está preguntando al abogado si la relación que usted tiene con usted es si es que es una relación que sigue o ya se está terminando.
Ya terminó.
No, es una pregunta para el abogado, señora.
Your Honor, to answer your question, no, this isn't an ongoing relationship, Your Honor. This was a residential lease relationship.
No, su señoría. No, su señoría, esto ya terminó. Esto era una residencia y ya no está.
It was entered. There was an LT, or landlord-tenant matter, that was pending. It closed with a judgment. Now there was a $7,138 balance, and then I believe now there remains that $3,000 balance that you mentioned earlier.
Your Honor, I'm going to have to withdraw. I am so sorry. I normally do not do this. The agency keeps calling me, texting me, and disturbing me. I cannot work with 3 people talking to me. I'm so sorry.
You're under a court order now to be right where
I know, Your Honor. I know, Your Honor.
Nobody is disturbing you or interrupting you or anything. We go in sequence. When I say something, then you interpret that before anybody else says anything. When someone else says something, you do the interpret. That's the sequence. I know that Zoom can be difficult because there are other sounds that come in, but we work with that. Now, I only need you for a little bit more of this. I guess my concern is that the complaint alleged damages at $3,600, and this was in August of 2022. And
La preocupación que tengo es de que había una deuda de $3,600 de agosto del año 2022.
And then there's an indication that subsequent to that time in December of 2022, that some $2,600 was paid. So I'm wondering, how is it still some $3,600 when the suit was for $3,600 and money's been paid since that time? That's my question.
Estoy indicando de que hubo un pago subsecuentemente en diciembre del 2022 por $2,600. Estoy ahora viendo y mirando por qué todavía hay una deuda de $3,600.
And Your Honor, so when we filed the complaint, the balance, the $3,600 balance was what was remaining after the garnishments that were being collected. And I believe that those garnishments ended on January 15th of 2021, which left that $3,600 balance. And Your Honor, I'm sorry if I said anything otherwise. The $2,600 payment, I don't have any $2,600 payment, which is I'd like to have, and if so, then I would definitely subtract that amount from the total balance due and give a new number out.
Su señoría, cuando yo archivé todo el balance de $3,600 era lo único que faltaba después de la orden que se dio de colectar. Creo que este fue colectado en enero del 2021. Disculpe si es que dije otra cosa. No tengo la cantidad de $2,600 anotado en mis papeles. Si es así la respuesta, entonces yo puedo restar esa cantidad.
Thank you, Ms. Valero. And Ms. Burnell, you indicated that as late as December of 2022, that a $2,600 payment was made. Is that correct?
Señora Marnell, usted dijo que en diciembre del año 2022 usted pagó $2,600.
Yo dije que el último pago fue, perdón, que le quitaron a mi hija fue en el 31 de diciembre del 2020 y que después adicionalmente le quitaron 1,368. En total, hacen un total de 3,958. Son $300 más de lo que supuestamente ellos me están cobrando.
On December 31st of 2020, that was the last payment that they took out of my daughter's account. And then after that, 1,368 was taken out, which makes a total of 3,958. It's $300 more than what the whole balance was supposed to be.
Well, I see the problem now. Earlier, it seemed that she said that the payment was made in 2022. She's saying 2020. There is a claim for in excess of $7,000 based upon the judgment that was entered in landlord-tenant.
Ahora veo el problema. Usted ahora me menciona el año 2022. Anteriormente, no, anteriormente dijo el año 2020. Habiendo un orden del tribunal por $7,000 anteriormente.
And the plaintiff is suing for the difference between that landlord-tenant judgment of more than $7,000 and the amounts that have been paid. They're suing the difference, and that's what this case.
El demandante está pidiendo la diferencia entre la cantidad de los $7,000 y lo que le han sacado. Eso es lo que está sucediendo ahora.
Pero yo nunca recibí, disculpe, yo nunca recibí que debía que pagar esa cantidad. Nunca recibí nada de eso.
¿Recibí o decidí?
Recibí algún papel donde dijera que tenía que pagar.
I never received a paper that showed me that I had to pay that account. Interpreter asked her if she said received or decided. It sounded the same to the interpreter. And she said, I've never received that I had to pay that extra amount.
That's what this lawsuit is about.
Es por eso que está en este juicio ahora.
All right. And so what's going to happen is that I'm going to schedule the next date in this case. I'm going to allow the parties to exchange information over the next 45 days regarding any evidence of payment and any evidence of amounts that are owed.
Ahora, lo que pasará es lo siguiente. Vamos a poner una próxima fecha. Se va a ver un intercambio de información entre las partes, que usted y el caballero. En 45 días vamos a tener que tener una audiencia y vamos a tener evidencia de pagos.
It seems to me that the starting place is the judgment that was entered in landlord-tenant court. Because if that full amount has been paid, then there should be no case here. But if that full amount, over $7,000, has not been paid, then that's what this case is about.
Me parece a mí de que vamos a empezar entonces con lo que se llama la entrada de la orden tribunal en el tribunal que se llama Landlord Tenant Court. ¿Ok? Si es que esa cantidad se pagó, entonces aquí en esta corte no habrá ningún caso. Si es que no se ha pagado, entonces se sigue el asunto de esta corte.
Disculpe, nada más para anexar. Mi hija tiene un caso pendiente por lo mismo, siendo que ya pagó, la siguen ella citando ¿en qué cortes? En el corte de Allen Park. También tienen un caso anexo al mío. O sea, yo no entiendo. ¿Va a pagar ella? ¿Voy a pagar yo? ¿Qué pasa?
I have an issue. My daughter also has a case pending in the Allen Park Court. So is she going to, and this is the same person asking for that amount of money. So is she paying or am I paying? Who's paying? I am confused with who is actually the one that needs to pay them.
I have no idea. The only case that is before me is the case in this court. In this court, Maria Burnell is the person being sued. And that's the only person being sued in this court.
No tengo idea, señora. Lo único que tengo delante de mí es la corte en mi corte con la señora María Bernal. Usted está haciendo que le llevan un juicio en esta corte.
Right. So this is 36 District Court. This is not
El
Allen
pago
Park.
fue en abril del 2021. El último pago fue en abril del 2021.
My last payment was in April of 2021.
Yeah, and the question is whether those payments add up to over $7,000 because that's the judgment that was entered in landlord-tenant court. It was not a money judgment, but it was a payment.
Señora, por favor, silencio.
Sorry,
La pregunta es si es que toda la cantidad que usted dice que ha pagado, si es que es más de $7,000, porque la orden del tribunal fue de $7,000. No, tal vez no era solamente lo que le tocaba pagar, pero por orden y costos y multas salía más arriba de $7,000.
All right, thank you, Ms. Valero. I'm setting the next date in this matter for 4/11. No, strike that. The next date in this matter is going to be April 3rd, 2023, and that's going to be at 9:45 a.m. And I'm going to send paperwork out with that date and with the right for the parties to exchange information.
Señora, la próxima reunión va a ser el abril 3 del año 2023 a las 9:45. El juez va a enviar documentación para usted para que cambie información entre usted y el caballero.
All right. And,
muy bien.
So I'm going to issue an order. You'll get it in the mail, and I will hear this case again on the 3rd of April. Right.
Voy a ordenar una orden que va a aparecer en el correo para que usted reciba todo, señora.
All right. Thank you. Good day to all. Thank you.
Gracias a todos. Your Honor, may I speak just to you?
Yes.
Could we make sure that, señora, es para asunto mío personal con el juez. Gracias. Your Honor, I just wanted to make sure I did not meant in any way to interrupt your court today. The agency that sends interpreters apparently overbooks us, and now she's telling me to go to another court and hang up. And I said, I cannot do that. I respect the judge, respectfully asked me to stay, and I'm staying. So she kept calling my phone. She kept calling and texting and calling. And so I was distracted, and I do not like doing that, Your Honor, because it reflects bad on my abilities and all that. But I didn't know what else to do. That's why I was respectfully asking you if I could just stop and tell her, stop bothering me because I'm working. But that's what happened.
Yeah, I knew you were under some strange pressures, and of course, this case is kind of while we were trying to get someone to help interpret, so that's why I was holding on to you a little bit, even though I know we're pulling in a different direction. So I thank you.
Right, and I understand, Your Honor, and I also understand that there was a number confusion. I guess judges have different Zoom numbers now, and our orders have been given prior weeks ago, so that makes it a problem as well. Thank you so much, and I apologize once again, Your Honor.
Thank you. All the best to you. All right. Thank you.
Thank you.
Thank you.
Bye-bye.
And Council, you'll get that order in the mail, sir.
Thank you, Your Honor. I believe I only have one last matter with you. It's with Miss Allen, who's also in the Zoom gallery.
All right. Okay, got it. And that would be case number 22-189-895. This is Debt Holdings LLC versus Martinique Allen. The matter is before the court. Looks like there was a filing of a motion for summary disposition. I have received an answer regarding this matter as well. And Counsel, you previously entered your appearance in a matter the court just heard. Enter your appearance, if you will, again regarding this matter, sir.
Good morning, Your Honor. Hamza Soba on behalf of plaintiff P2080.
All right, thank you. And do I have Ms. Martinique Allen on this one? Say something if you're here.
Martinique Allen is here.
All right, thank you, Ms. Allen, and thank you for your patience as well regarding this matter, ma'am. I received your answer in this matter. Looks like it was filed with the court on the 3rd of February. I also received the plaintiff's motion for summary disposition in this matter. You received a copy of that as well. Is that correct, ma'am?
Yes.
So they're asking the court to decide this matter on the basis of there not being a genuine material issue of fact, and that there is no significant dispute regarding the claim in this matter. So let me hear from counsel in that regard, and then I'll come back to you to see what you wish to see on those issues. Counsel?
Your Honor, and before I begin on the motion, I would ask the court if the court has received a response to our motion, because we haven't received anything with regards to that.
Ms. Allen, you didn't file any written response to the motion. Is that correct, ma'am?
Yes, I filed it on the 3rd, I'm thinking. It was.
That was not a response to the motion. You filed an answer to the complaint. And I suppose what you're indicating is that you'd like for that answer to be treated as a response to the motion as well.
Yes.
That's not really the way it works, but I get what you're saying. So go ahead, counsel. You understand the scenario. Go ahead, sir.
Okay. Then let me just. I'm sorry, Your Honor, my computer's being really slow. It's taking time to open up the file. Here we go. Okay. So Your Honor, this is a matter that's arising out of a commercial lease agreement. That lease agreement, which is included in our motion, required the defendant to pay contractual monthly contractual obligations. the rental amount. It was a valid binding contract. There's no dispute about that. I believe since Ms. Allen didn't respond to our motion, I would say that there's no dispute as in the fact that she failed to file or failed to submit those rental obligations, ultimately leading up to a breach of contract, which is where our motion would arise out of.
And so, Ms. Allen, in this regard, she's filed an answer to the complaint, but not any response to the motion. There appears to be a contract that was signed for the rent of commercial property. And is it in fact true, Ms. Allen, that you did in fact sign a lease for rental of a piece of property in this regard? Is that true, ma'am?
Yes, I signed a lease agreement between me and it's 7 Investments LLC. And in their motion, they have that I signed the lease agreement between Debt Holding and LLC, and I never signed a debt. I mean, I never signed a lease between them or acted as a tenant, or they was as my landlords at all.
And in regard to the lease that was signed with the agency that you mentioned, ma'am, just kind of looking at some of this, there came a time where you no longer made payments under the lease. Is that correct?
No, I made payments. It was ordered to be placed into escrow of $790. And then the escrow was released back to me as a judgment back to me. And then we had also went into a landlord tenant case. And then also we agreed for me to voluntarily vacate with a zero money judgment and a zero money possession judgment. And Judge P. Penny Millard courtroom.
And Your Honor, if I may, to respond to that, Your Honor, the Summary Proceedings Act allows us to one, if a money judgment wasn't requested and the issue of money wasn't litigated in the landlord-tenant issue, then we would be clear to file a separate action for the money in the general civil action.
Yeah, I mean, that's the way the law works. A landlord-tenant case can be resolved in a number of different ways. Sometimes it's resolved as a pay or move type situation, and that's still not a money judgment unless the parties agree to a money judgment. Other times it can be resolved with the parties agreeing to go their separate ways without engaging money in the ending of the relationship. That does not avoid the contractual obligations that may exist regarding what a party was obligated to do under the contract. It just releases the premises back to the landlord. So there's nothing, unless there is an order presented to me that shows that the parties stipulated either on the record or in some written order that says that they waive rents that may be due or waive the contract, no longer are seeking damages under the contract, there would have to be some type of release from the obligation of the contract in order for there to not be the ability to sue based upon a claim that there is an indebtedness. All right. The other issue that was raised here is that Debt Holdings LLC, the plaintiff, straight that defendant in this matter, says that she did not enter into an agreement with Debt Holdings, but with another agency by another name. Counsel.
That's correct, Your Honor, and I apologize. That's a typo on my end. But the agency she did enter into an agreement with is a subsidiary of JMC Management, who also owns Debt Holdings, and the agency she did enter into a lease agreement with.
All right.
But in response to that, Your Honor, it was a typo. between 7 Investments and Debt Holdings, Debt Holdings being the plaintiff in the matter.
All right, the reality of it is is what you're pointing out here, is that this has to do, and by whatever name it is, this has to do with the debt that arose by virtue of the relationship, the contractual relationship regarding the property on East 7 Mile Road, in the city of Detroit. Is that correct?
That's correct, Your Honor.
So that's what this is about. So why shouldn't you owe the money that approved by virtue of the contract of Ms. Allen?
Because I never breached my lease. Everything that they have in sections and stuff, I have sent over everything from my documents from the trash removal contract, was it my assurance company, the service for the heating and cooling, the agreement for the 36th District Court, where I had placed all the money into escrow, and that's where it was getting paid to until they fixed the roofing, because the roofing was leaking very bad that I could not conduct business out of there at all.
All right. And as part of the, who was responsible for the roofing under the lease?
JM Management.
Counsel?
Your Honor, under the lease agreement, it would be the tenant that would be responsible. I indicated at the last hearing it was one section 3.01, which is as is condition. That's what it's labeled as, the paragraph, and then 2, it was section 6.01, which is labeled as tenant's obligations.
All right, so here's what I'm going to do. I'll take your motion under advisement. Miss Allen, you will need to respond to the motion for summary disposition. You'll need to respond item by item as to why the court should not grant the motion, because it appears that there was a lease agreement, that the terms of that agreement dictates the outcome of this case. And that doesn't have anything to do with what may have occurred in landlord-tenant court. There's not a judgment, quote unquote, against you in landlord-tenant court, nor is there a judgment that waives what your obligations may have been under the lease agreement. So I need you to respond to the motion. So I'm going to set a date for you to do that. You got your answer in. I'm going to set a date for you to respond to the motion in writing, and then I'll come back to this motion to determine what the outcome should be. So I'm going to bring this matter back for a hearing on let's set it on the 15th of March, 3/15, 23. And what you'll need to do, ma'am, and that's going to be at 10 o'clock a.m. What you'll need to do is you'll need to file a written response to the motion not later than the 23rd. The 23rd of February. So you have until 2/23/23 to file your written response.
Pardon me?
You have until 2/23/23 to file your written response. Whatever you're going to respond to this motion.
Hello?
Are you hearing me? Can you hear me, Ms. Allen?
Your Honor, I can't hear you.
Are you able to hear me, Mr. Schultz?
I can hear you, Your Honor.
All right, Ms. Allen, are you able to hear me now? All right, so I don't know what happened, but everybody was hearing me and now you can't hear me. So what I'm gonna do is I'm going to issue an order that respond to the motion not later than February 23rd, 23. And then the hearing date is going to be 3/15/23 at 10 o'clock a.m. That will be the next action date in this matter. All right. I wish both sides well. You get an order from me regarding the things that I mentioned in the next couple of days. All right. Good day to the two of you.
Thank you, Your Honor. Have a great day.
All right. The court now calls case number 22-195-205. This is CKS Prime Investments LLC versus Lawrence Gardner. The matter is before the court pursuant to a scheduling order, and this is the pretrial conference date in that regard. Your appearance for CKS Prime in this matter.
Good morning, Your Honor. Me, Kalish. My P number is 52383 on behalf of the plaintiff.
Thank you, Madam Counsel, and good morning to you. And thank you for your patience and having to learn a little bit of Spanish this morning while you were waiting. Hopefully it worked out okay. And you get to be last today. I don't know what all that means, but here we are. All right. Do I have Lawrence Gardner on this Zoom? Lawrence Gardner, if you're on the Zoom, say something at this time. If you're on mute, you can press *6 and that will take you off mute. I'm looking for Lawrence Gardner. All right, the person with the case ending, the phone number 608, who are you? I'm looking for Lawrence Gardner. Lawrence Gardner? All right. It appears that that person has not appeared. I don't see any notation from them. Have you spoken with that person at all, counsel?
I have not. It does appear to be the defendant's phone number.
Yeah. Oh, it does?
It does.
Let me see if I can. I'm looking for Mr. Lawrence Gardner. Gardner, sorry.
It should, there we go.
Yeah, I'm here.
Oh. All right.
Yeah, I'm here.
All right. You're Lawrence Gardner?
Yeah, I'm here, sir.
All right. Thank you. Good morning to you, sir.
Yeah, good morning
All
to
right.
you, sir. Yeah, good morning to you.
So
Happy
this
New
is-
Year to you.
Thank you. Thank you very much. All right. So we've gone through a period of discovery in this matter. And so I guess I need to hear updates at this time. Madam Counsel, what can you tell me about where we are at this point?
Your Honor, is not resolved. I believe this is more of a hardship defense on Mr. Gardner's part and a substantive legal defense. We have had a few conversations with him. We've been unable to settle the case. And at this point, we have filed a motion for summary disposition. I believe we're waiting for the court to set a hearing date for that motion, and that's where we stand today.
Sir, can I say something? Okay.
Just one moment. Just one moment.
Okay.
So when did you file your motion on the council?
The motion was filed on, let's see. It looks like it just printed today, Your Honor, so it probably is going to be reviewed and sent to the court.
Got it. Because I know I hadn't received anything or it had not populated the file. Okay, so we'll set that up. Mr. Garman, sir, go ahead, sir.
Yes, sir. What I wanted to say is I tried to make a settlement with the law firm. This was the information that was said to me. A gentleman on the phone. I don't know if he was an attorney or not. He told me $1,000 for the settlement because I had to go borrow the money from somebody because I don't work. And then on the 23rd, on the 26th of January, I talked to a lady named Heather at the law firm, and she told me I had to come up with additional 1840, and I don't have the money.
So you didn't get any of those items, did you get either of those settlement numbers in writing at all?
I wrote it down. She wrote it down. The lady at the firm wrote it down. She told me, she said, Mr. Gardner, I'm gonna write it down, and and I left it at that.
Okay, well, now you know, Mr. Gardner, you know what I'm talking about. Did you get something in writing from the firm?
No, right. Yeah, they never sent me anything. Yeah, I know what you're saying. Yeah, they never sent me anything.
All right. So, what do you, Miss Kalish, what do you know about the attempts to settle with the office here?
I do see a telephone call on January 26th, 2023. We did $1,000. We gave him a number. I'm not comfortable sharing details of the settlement in case this matter doesn't come up. But we did talk to him and said that possibly we could use that $1,000 as a down payment toward the amount that my client would accept.
Did you have any notation indicating an offer of settlement for a $1,000 amount in total? Because the defendant said
that was not accepted, Your Honor. We countered that.
Oh, he made the offer and then you guys countered it with something else. Is that what you're saying?
That is correct.
All right. So whatever the settlement, whatever the offers, counter offer settlement number, is that still on the table?
The counter offer is, but it doesn't appear that he wanted to accept that amount.
So, Mr. Gardner, you were not interested in accepting the counter offer that they're talking about, whatever it was?
No, because see, the reason why, because see, I don't have any money. I don't work. And the $1,000 was given to me by a friend. And I was going to settle the debt with $1,000. Okay. That's what I was told at the law firm. The gentleman at the law firm told me $1,000. I said, okay. He said, make sure you have it in by the 31st.
You already told me that. I got you. I'm not
okay.
Cutting you off.
Okay.
Got you on that. Here, listen to me carefully. If they sent you something in writing that said that we will settle this for $1,000 by such and such a date, then they would be bound by that. If you don't have, that's why I asked you about the writing. If you don't have,
right, they never sent it to me. Right, they never sent it to me.
Let me stop you, and then I'll let you talk. I'm gonna let you talk. Let me stop you. So you even if somebody told you that, they would not be bound by that unless you got something locked down in writing on that. The other thing is that now what you do have, and there is agreement now that there is a counter offer that's on the table. I understand that you do not wish to accept that. One of the reasons that you told me two reasons that you don't want to accept it. One is because something that was told to you previously, and two, because you don't have the money for it. The question becomes, if there is an agreement to allow you to make incremental payments to resolve that, are you willing to reach a settlement in that regard?
No, I'm not interested in making a payment plan. The only way that I would agree anything is that settlement that I told you, that $1,000. But as far as a repayment plan, no, I'm not interested in that because I don't work.
I got you. All right. So the reason I asked you that is because the next thing that will happen is a motion will be filed for summary disposition. That motion for summary disposition will basically raise the issue of whether or not you have a real defense to the claim that's brought against you. And if you don't have a real defense to the claim brought against you, then what will likely happen is a judgment will get entered against you for the full amount of the claim. And the full amount of the claim at this point is $3,300 plus whatever court costs and that kind of stuff is. So it looks like to me, and of course, well, it looks like to me that what happens here is that if you don't have a real defense to this, then you may end up with a judgment that is somewhere in excess of $3,500 versus settling it for something that is less than that amount. That's why I asked you all those questions that I asked you. You understand?
Yeah, I got you. I got you.
All right, so I'm gonna set it up for a motion hearing date. You'll get a copy of the motion in the mail. You should take some time to respond to it if you believe that there is something that you have to respond to the motion once it's sent to you. And I'm gonna set that motion on for hearing in front of me. I'm gonna set it somewhere near the end of March. Let me see. I got a family dinner, and my wife is insisting that I actually take it. So that's gonna run me into. So that's what I'm working around. All right. So let me see if I can. I'll go ahead and set it for April 4th, 2023, and I'm setting that for 10 o'clock a.m.
10 o'clock a.m. Okay.
So you'll get
April 4th, right? Okay.
April 4th, and you'll get something in the mail from the court with that date on it. And you'll get something in the mail, Ms. Kalish's office with, it will be a motion for summary disposition. And you'll need to respond to that, and then I will hear it on the 4th of April, right?
Very good.
All right.
Thank you, Your Honor. Thank you, Mr. Gardner.
Yeah, you too. Okay, thanks a lot.
Thank you.
Okay.
All right, and
Thank you.
And ma'am, what matter are you here on?
I'm here with against Richard Rawson for credit acceptance.
I'm sure I heard that case a long time ago. What's the case number?
221-82136. I have been sitting in a different courtroom since 9 o'clock. The number that they gave me on my paper was 534, and clearly that was the wrong
First
courtroom.
case, Judge. Well, wasn't first, actually.
So do you have, it wasn't the first case, but it was
The first on the docket, but it's the fourth one you called with Miss Francis.
So is this the, what was it, Charday Lane?
Yes,
Is that who you are?
yes, I am.
All right. What did we do on that? What happened on that case?
You denied her motion. The motion denied. I think she must have filed a motion. But she didn't show.
So yeah, I denied the motion in this matter, ma'am. You were asking to pay $50 a month on a judgment that is $12,345. I set it up for hearing to find out if there was some other amount that you were willing to pay, because I can't set you a $50 a month payment for a $12,000 judgment. It would take, I think we came up with, it would take 500 and something months to pay this off.
Yeah, and I had got a paper for $262. And if I was to sign an agreement to that, then I was gonna be back in court because I know I wouldn't be able to afford $260 something a month on top of my bills, my kids, and the other debt that I have.
Let me stop you. That sounds like something that you received from credit acceptance where they wanted you to pay that. But that doesn't mean that you'd have to pay that amount. I don't know anything about that. But when you file.
Oh, okay. Yeah.
When you file a petition for $50 a month, if you file something, it's gotta make some kind of sense. And $50 don't make any sense. It looks like you're being garnished on this too. Are you?
Yes, yes.
Well, see, that's the big deal. Have any money been taken out of your check, ma'am?
Not yet. They stopped it once I came to the 36 to to file for a motion for installment. It stopped it, but I had just put down, I just threw out an offer, $50. I kind of figured it would get denied, but that was just like the range from where it could start from. But I know that $200 is very steep, and I do not want to I don't want to backtrack. I don't want to start it, and I can't afford it.
Here's what's going to happen. I mean, the bad thing here is that you get paid every week, right?
Yes.
Okay, so how much do you typically bring home?
I bring home 500.
Right. So if when they start hitting you with that garnishment, if you bring it home 5, then 25% of that would go to the garnishment. So 25% of that is about $175. So that would be $175 a week. So your garnishment rate is going to hit you for 325 every 2 weeks. So $650 a month. That's a problem. And
that is a problem. I wouldn't be able to make it. I would literally have to quit my job and try to find some under the table because I'm barely making it off the 5-something a week.
Right, but that's I mean, therein lies the problem. I mean, that's why you're getting the thing from credit acceptance. They know that that they've got a garnishment against you. They know that Ford is required to start issuing a weekly check to them for roughly $175 a week. And so that's why they're saying, look, she's gonna have to pay $650 under the garnishment. So if she'll pay whatever amount they were asking that you pay, then their basic position is that we'll back off the garnishment. And you don't have in front of me an objection to the garnishment. You only have a petition for partial payment. And then the amount on that was unreasonable. So
well, I thought I'd fill all of that out. When it comes to the court, I will be a little illiterate. So when I was up there at the lady counter, I kind of asked her everything I needed to do. And I thought that she had gave me the thing so I can stop the garnishment. And so I thought that was one of the things that I filled out, which it was 3 packets I got downstairs that I filled out. I'm not sure which one, but that's what I wanted this court date for. That's what to stop the garnishment and to negotiate a settlement.
yeah, you don't have a position in front of me to stop the garnishment. And it's not the duty of the clerk to give you advice as to what you need to do, even though they might want to. They're prohibited by law from doing that. And I understand. That's why we're taking a moment to kind of talk about this. Is that I understand that you're no lawyer, you don't come and stuff like this. So you may not know all of what to do. But I want you to understand the implications of this. The biggest thing that you're dealing with is that garnishment. Because there's a judgment against you, the plaintiff has the right. I mean, they can garnish your bank account, they can garnish anywhere that you've got money. But the biggest garnishment is typically the garnishment against wages, and they have a garnishment already in place. And the money should have been taken out by now already. And you don't have anything really to stop that, even though you filed a petition for installments. I don't know why Ford Motor Company has to take the money anyway. They don't have any reason to stop. They should be stopped. But that's the conundrum that you have. The only thing I can suggest to you, I set this hearing. Typically, I wouldn't even set a hearing on something like this. I set the hearing because I saw this $50 thing, and my initial reaction was to just deny it because you can't pay $50 on $12,000. But then I looked further and I saw that you put on here that there was a garnishment with Ford. I said, well, wait a minute, if I just deny the amount, then Ford's going to keep collecting. And I know if you work at Ford, your garnishment is going to be at least $150, probably $200 a month, a week. So that's why I set the hearing. And then, of course, we have a problem here that we kind of straightening it out with the Zoom numbers. This is the correct Zoom number, but some of the notices had the incorrect number, which was the 534 number. So that's not your fault. That confusion is not your fault. So let me do it this way. I'm going to go ahead and set it up for you to come back on the 21st. The 21st of February.
Okay.
2/21/23, and I'm going to set the time there at 9:30 a.m. And we're going to send something in the mail, but the mail gets funny now, so make sure you take this Zoom number down: 360-336-0000. Right? So 360-336-0000.
Okay. Got it.
00. That's 9:30 on Tuesday, the 21st of February. That's when you need to come back and see. We're going to notify the other side and order that they be here as well. So maybe you could talk about a way of trying to get this resolved going forward. Otherwise, you're going to be getting, they're going to be collecting $650, maybe as much as $700 a month. Okay. The law allows that. It allows 25% of your take-home pay. So you definitely.
So, Your Honor, I'm sorry. I know you said that the court can't tell me anything, but being advised through my judge, could I ask you, should I go down here and file a motion to stop the garnishment? That's what I thought I did at first. If I was to do that now, could I take this to court? Because I know that once we come back, they're going to hit me with a steep number that I know I won't be able to. I will be back in your courtroom because they're going to say that I didn't follow through with my payment. So is there anything I can do?
Listen, you asked a couple of questions. One is that the ultimate determination of what you will have to pay a month will in some ways be left up to me. And that's why you're coming back. But it has to be a reasonable payment.
Okay.
If you had a judgment that was $3,000, then, then we can set a payment that is reasonable based upon $3,000. If it's $5,000, if it's $8,000, your judgment is like $12,000. So it has to be a reasonable payment. And if you can't set a reasonable payment, then you're stuck with the garnishment. And the garnishment is going to be $650 at least. Okay. That's that. So you have to figure out within that rubric. And then you don't want to, whatever the payment is going to be, you want to keep that payment because that only suspends the garnishment. Don't remove it. Meaning that if you don't make the payment, the garnishment kicks right back into place and you start getting hit with the $650 a month. So you gotta figure that out. You asked me whether or not you should file objections to the writ of garnishment. I can't give you legal advice, but I'm gonna ask you a question. Should you file objections to the writ of garnishment?
Yes.
Oh, okay. All right. So I will see you on the the 21st February at 9:30. So just I'll be here, and the other side will be here as well. All right.
Thank you. Thank you, Judge.
All right. Good day to you.
You too. Bye-bye.
All right. So on this one, I'm going to do, I don't know, she already set this up for mailing out. That was that credit acceptance versus Sadie.
Yeah, but I haven't sent.
Yeah. All right. So just hold them, and then we're going to issue a notice of on this date, 2/20/21. That's the file.